think generally people in Canada feel like their property rights are secure. They're not worried about someone coming and taking all their stuff, and there not being any way to remedy that. They're not concerned that some government actor is going to come and do the same thing in general. But I would say it's precarious in the sense that there are these sort of default protections, but it's very easy for government to override them. And if you find yourself in the circumstance of one of the unlucky few that is affected in this way, your perspective would change completely, and you'd feel a little bit more of the injustice.
Welcome to Inside Policy Talks, the podcast of the Macdonald-Laurier Institute. I'm Peter Copeland, Deputy Director of Domestic Policy here at MLI. And across Canada, some of our most heated disputes, from housing restrictions to Indigenous land claims and expropriations, turn on a simple question: how secure are Canadians' property rights? And the answer may surprise you. Canada has robust property rights protections, to be sure, but is one of the only developed countries without a constitutional protection for property rights. And that gap arguably has real consequences, whether it's family farms shuttered by regulation, homeowners caught in civil forfeiture, or recent court decisions like the Cowichan Tribes that upend long-held assumptions about ownership itself. So today we'll be exploring these questions with University of New Brunswick law professor Paul Warchuk, who's written a powerful new paper for MLI on property rights in Canada. In it, he traces the philosophical and legal evolution of property from thinkers like Locke and Aquinas to the Charter era here in Canada today, arguing that property is not only a private entitlement, but public trust, one that safeguards liberty and prosperity and serves our common good. And before we get started, please remember to like and subscribe. It really helps us reach more people with these ideas. Professor Warchuk, welcome to the podcast.
Thank you. I'm excited to talk about some of these interesting issues.
Yeah, when we started this paper, recent developments had not occurred with Cowichan, but there have been many in recent years. Think of the Emergencies Act and civil forfeiture. We'll get into all of these things. Property rights, I think, are on Canadians' minds. And you opened the paper, Paul, with a pretty striking observation. Canada stands virtually alone among developed democracies in having no constitutional protection for property rights. For many, I think it sounds like a very abstract legal point, yet it certainly has consequences. So in your view, what does this mean in practice, and why does it matter?
What it means, so legally, what it means is that the government has the authority to interfere with property, take it away, or even destroy it in a manner that most other governments don't. And that's because most constitutions protect property rights. Now, and when I say protect property rights, I don't mean absolute protection. I think everyone agrees that there has to be some middle ground between property holders' right to do what they want with their property and the needs of the public and the needs of the general society the property is in. It's just Canada draws that distinction, or that line between the two, much closer to the regulatory freedom side than pretty much every other developed country. Usually there's some form of protection in terms of compensation requirements, just cause. There has to be a reason, a justification for taking the property or destroying the property, and then also a due process. And none of that's in Canada's constitution, which means we get these situations where more and more, it seems, property is being taken without any kind of recourse for the property owner. And I should say, I think Canada is pretty aligned with the other countries in terms of protections against third parties taking property. Strangers. We have robust police and civil remedies for those sort of situations. We're mostly dealing with the case where it's a government entity itself, or something that I think a lot of people don't know about is there are other sort of certain designated organizations like utilities, railways, telecoms, that also have these statutory powers to take people's property in certain circumstances.
Okay, that's very helpful. Now, you mentioned a few things: takings, compensation, due process. Those are often entrenched constitutionally in pure jurisdictions. Now, in many circumstances or contexts of law or policy, those certainly do exist, I'm sure. But is it perhaps the case that the landscape is variegated and patchwork in Canada? Do we, to what extent do we have these things?
Yeah, I think that's right. So the one area where it's pretty consistent across the board in every province, there's protection for outright expropriation of land. So every province and the federal government has a statutory regime to protect landholders when the government wants to take that land. There's a procedure to follow, there's fair compensation requirements, etc. When we start moving to other types of property, that falls away. When we start moving to not situations where they're not outright taking the property, but maybe regulating it to the point where it can no longer be effectively used, that's when we get into these situations where there's no protections and where you're kind of dealing more on an ad hoc case by case basis. So sometimes government will enact compensation, other times it won't. And it's just sort of, as I said, a case by case. So yeah, patchwork quilt sort of
Mhm.
where you have one area where we can debate how robust protections are in the expropriation context, but normally it's a matter of degree in terms of okay, what is fair compensation? How do we calculate compensation? How do we determine the situations which government is justified in taking property? Whereas in those other contexts, it's sort of there's no blanket protection to speak of, and we're dealing more with um, yeah, the individual circumstances and whether government wants to compensate in those cases. And
Okay.
also, I should say too, a lot of the time it comes down to the power of the group whose property is being taken. Did they have the political power to convince legislators to put that compensation clause in or not?
Okay, that's really clear. Let's get into some of the examples where you see perhaps a poor, to be improved upon levels of protection. You note in your paper some significant ones like wartime seizure of Japanese Canadian property, the Emergencies Act declarations around the convoy, this recent Cowichan Tribes decision just this year, which seems on its face to override a fee simple private property, which is the most stringent type of protection. Help us understand some of the most salient examples where property rights or protections are perhaps weaker than you think they ought to be, and what sort of common threads underlie them.
Yeah, I mean, there are just so many different circumstances that come up. As you mentioned, the emergencies context is always a situation when sort of law falls to the side and the emergency takes priority and people do what needs to be done. Now, I mean, traditionally, people have acknowledged this is, emergencies are the situation where government is most justified in interfering with property. The sort of classic early modern example would be when there's a fire spreading throughout a city, the city officials are justified in demolishing buildings as a fire stop to prevent the fire from spreading to the entire city. Uh, but on the other hand, it's that needs to be backed up with compensation to the people whose property is being destroyed or taken away uh, in order to sort of protect the common good from this emergency. So yes, I think emergencies are kind of a perpetual issue in not just property but all sorts of rights areas. You mentioned also sort of civil forfeiture in these areas where there's a fine balance to be struck between uh, how far to go in terms of preventing crime and uh, disincentivizing that sort of behavior, and then also protecting innocent people. And I think
Mhm.
in that area, uh, due process and those sort of ensuring that it gets before a court, ensuring that the procedures are in place to prevent mistakes from happening are what's critical. Uh, I can't not mention, I guess, taxation. I think everyone sort of accepts it. I don't think people think of it in the same way because there's not maybe that sense of unfairness. People kind of expect to pay taxes nowadays, but that's
Yeah.
another area where
Hmm.
property is being taken from people for the public. There's all sorts of areas of where property is destroyed too. We've recently seen in the agriculture context, right, to where there's an infection. The CFIA can order the destruction of a whole herd or flock, and obviously that has major financial consequences for the farmers or involved. And but other areas, sort of the area that I think where this comes up most is through we can use a catch-all phrase, regulation. So regulation of property, whether if we're looking at land, usually zoning, environmental protections. Sometimes you have building codes and regulations, and in all these areas, the intent is the same, which is to do something to benefit the public. But often what's sort of forgotten about or left behind is the interest of the few people that will be negatively affected by the law and whose properties values might be diminished, or their properties may no longer become usable. And sort of those are the situations where we need more protections, in my view.
Yeah, no, I can see that, and just hearing you go through the examples, the things that stand out to me as lacking most are due process and a just form of compensation when these various types of explicit or maybe indirect through regulations that affect the use or the value of your property are in play. So let's get into those a bit further. But before we do, I want to talk about two kind of poles of the different principles that are involved here. And kind of the philosophical evolution of property rights frameworks. You contrast Locke's natural rights view in your paper. Property is kind of this pre-political right rooted in the labor that we mix with the land or what have you, and then we derive a right from that. With other natural law thinkers like Aquinas, who say where ownership is of course a good in itself and it's to be stewarded, but it's kind of for the sake or embedded in this context of a common good, and those considerations need to come into play to a certain effect. So, how did our contemporary property rights framework come to be, and how do these two traditions or poles, I guess you could say, complement each other or exist in tension, and why does it matter today?
Yeah, I think, as you said, they do complement each other. I think uh, that very few people take this sort of extreme position on either side that, well, there should be no individual property, everything's for the collective good, or everyone should have the right to do whatever they want, and there's no sort of oversight over people's property. So I think the difference is sort of in the emphasis. Which way do we go? A little bit more towards the individual owners, or a little bit more towards the uh, good of the general public. And what's important to point out is even with the natural law thinkers who were in favor of the public being able to sort of have some say over how people use their property, is that they thought when property people are deprived of their property, they still should be justly compensated for that, right? At the end of the day, it's sort of a basic fairness point that yeah, people, when you take away something from people, they will feel like they've been harmed and there's some sort of injustice. And we can't always remedy the sort of maybe attachment someone has to a particular place. Let's say it's a family farm. You've been uh, farming that land for 100 plus years. Very difficult to compensate that feeling. But at least we can take a little bit of the injustice away by providing some form of compensation over nothing at all. But
Hmm.
yeah, so just to get back to these, I would say they are complementary. I think Locke was concerned a lot about, the role of government in protecting property um, from other people too. Is a part of the rule of law is this idea that we have a enforceable system of property rights where people can't just come and take your stuff and claim ownership of it because they're more powerful or they have more guns or whatever the case may
Hmm.
be, right? So there's a legitimate role for government both in protecting people's property, but also ensuring that property is used for the benefit of everyone in some cases. So even like at common law, which traditionally had strong property protections. There's protections for other property owners who, a nuisance, for example. You can't use your property in a way that harms other people around you and causes a nuisance. So
Hmm.
I guess the main point is just it's all a balancing act, and
Yeah.
the question is where to draw the line. But I think, at least in Canada, maybe we've drawn the line a little bit too far in one direction.
That's very interesting. Yeah, and in particular, just seeing in the paper indicate how those natural law thinkers kind of gave rise to the justification for fair compensation and helped kind of balance things out. Another thing that I think of in terms of the development of the contemporary state is the work of Hernando de Soto, who's an economist and did a fair bit to understand the extent of property rights protections around the world. And he famously shows that those countries with very poor property rights regimes, their economies suffer a great deal as well because there's just not a clear information system, and value cannot be stored and accounted for properly when you don't have even just an inventory, right? But also the rights that go with it. So it's an economic enabler. It provides social cohesion. People are invested in it, and then it also needs to be balanced with these various common goods, so that the balance is right. So let's talk about that balance now. You said the side is tilted, maybe to one side or the other in Canada anyway. Why don't you elaborate on that? I would say, just maybe to start, for most people or in many contexts, perhaps, although maybe not these examples of all the ways in which regulation reduces your value or the potential uses of your land, but in many contexts, Canada has pretty robust, strong property rights protections. So how would you characterize the state of our property rights regime here? Is it only certain circumstances where it's quite bad, or is it kind of death by a thousand cuts, if you will, through insufficient protections and compensation for all of these ways in which properties value and use gets restricted?
Yeah, I think you're right. It is fairly robust. Again, going back to how do people feel? I think generally people in Canada feel like their property rights are secure. They're not worried about someone coming and taking all their stuff, and there not being any way to remedy that. They're not concerned that some government actor is going to come and do the same thing in general. Uh, but I would say it's precarious in the sense that there are these sort of default protections, but it's very easy for government to override them. And if you find yourself in the circumstance of one of the unlucky few that is affected in this way, your perspective would change completely, and you'd feel a little bit more of the injustice. Um, so yeah, if we look at it in terms of maybe the zoning situation with land. In general, zoning laws are made to benefit everyone in the community. People don't want, I don't know, 100-story tower being built in a neighborhood of small, 2-story houses. And so they're meant to benefit people. But on the other hand, you might be the one owner who purchased a lot. It was zoned commercial. You were going to build an office building. Suddenly, they alter the zoning because people don't want an office building in their community. Your property value plummets to half, or I don't know, a tenth of what you paid. And uh, for everyone else in the community, they think it's great. Our community won't be ruined by this large office tower or whatever. But for that person who owns the land, it's a very different story and a very different feeling. If they're left sort of holding the
Mhm.
bag, so to speak, for the benefit that's been given to everyone else in the community. So I think, yeah, I think it's sort of a getting back to the checkerboard. It's sort of where you are on the board. Um,
Yeah.
that's how your rights will be affected. And then you just never know when it's going to come up too. I was just reading every so often it comes up in the news where the police might accidentally kick down the door of the wrong house. They're executing a high risk search warrant. They need to kick down the door, use the flashbang grenades, and it turns out it causes a lot of damage. And also turns out that there's no sort of robust system for compensating people whose property has been damaged, unless the police were absolutely negligent. But if you're in a situation where, in a building, they may have gotten the wrong unit number, the person may have used to live there, they moved out, all these sort of contexts where your property can be damaged totally unexpectedly, totally uh, for legitimate reasons, in a sense, right? The police are trying to catch a criminal, they're trying to enhance public safety. So it's for the public good that the search was conducted. Unfortunately, though, it's one homeowner whose property has been destroyed. And if you're that homeowner, your property rights feel pretty insecure if the police can just barge in and, cause tens of thousands of dollars of damage and not compensate you for that. So as we were talking about earlier, there's just so many different situations where this can come up, and that's why in the paper I talk about creating more of a default or across the board property protection so that
Mm-hmm.
all these little one-off situations can be covered by the same robust protection.
Yeah. Very good. Yeah, and I certainly think of natural resources and major projects as another key area that comes up increasingly in Canada today. So we'll come to your policy proposals, but this is really clear in illustrating the trade-offs, and you can see why government wouldn't want very strong, compensation
Yeah.
requirements, because it might also prevent certain decisions from being undertaken, and so that's an important thing to consider, which we'll come to. But of course, there was an opportunity to entrench property rights in our Constitution when the Charter was adopted in 1982, and so there's a bit of a history there. It was on the table, the inclusion of property rights, but they were excluded largely for political reasons in the negotiations. So tell us a bit about what happened there. Did that omission, reflect kind of a sincere philosophical stance, or was it what drove that?
Yeah, I mean, as with any kind of, I guess, complex group decision, there were a lot of different people with different perspectives, and and some of them I think were certainly philosophically driven. So at the federal level, when it came to negotiating the charter, the NDP came out strongly against it on a principled basis. Up until sort of the 1980, 1981 negotiations, all of the drafts that the Trudeau government had prepared had included property rights, and I think it was an expectation that it would continue to be included in the final document. And both the federal Liberals and Conservatives supported it. It was the NDP, though, who made it a very big issue for them, and some provinces also objected. There was some concern about impacting the ability to regulate land and other property. Some provinces were concerned in particular about foreign land ownership, which they wanted to restrict. And so I think it's a combination of political expediency, maybe people saying, listen, we'll compromise here and maybe we'll get another right or some other part of the
Yeah.
charter that we want. Also, some people had principled objections to it on the basis that, oh, maybe it only protects the landed interest, so to speak. It only protects people with
Mm,
a lot of property, and it's going to prevent us from doing all sorts of regulation. And then there's sort of the third group that Dwight Newman has argued maybe a little bit were misinformed in the sense they weren't aware that what would come, which is other other parts of the charters, notably Section 1 and Section 33, which allow
mhm,
government to limit charter rights in a way that's justifiable, or
mm,
ultimately to use a notwithstanding clause uh, such that their legislation would operate, notwithstanding that it violates or runs contrary to a charter right. So potentially, if those had been in place or known to be part of the charter at the time property was negotiated, you may have not had the concerns of the provinces. It's all so difficult to.
hindsight's 2020.
Yes, yeah. Uh, I'm preparing for teaching statutory interpretation next semester, and one of the great debates in interpreting statute is there legislative intent? How do we determine what the intent of this group of people who created legislation was? And there's a great example of that where a lot of different people had a lot of different interests, I think, and it just resulted in the exclusion, which has had fairly significant effects. Often I've seen, well, maybe not often, but in several cases, I've seen courts reference the explicit choice to exclude property as a sort of way to diminish property rights and say, they weren't important. It wasn't important enough to put in the charter. They chose not to protect it, and so, too bad for you, to the
Mm.
person who's trying to claim some sort of protection.
Interesting, yeah, because the reasonable limits clause, it just applies to charter rights, right? So I suppose, if it were included, then court would have a pretty strong. It would be hard for them not to require of governments some form of just compensation, even if it weren't explicitly in statute, hypothetically.
Yeah, absolutely. Like, it would be difficult, but it wouldn't be impossible. I mean, it's just like it's possible for the government to deprive someone of life, right? Which it can be just it could, but in theory, could be
Yeah,
justified.
fair.
So yeah, that I think in the property context, probably be much easier to come up with a situation where there could be some justification for maybe compensation less than what is just, or I don't know, something along those lines, less than fair market value. I mean,
Mhm.
that's part of the complication, which maybe we'll get into later too, with with a constitutional right, is we don't really know what the scope of the right will be until courts start interpreting it. And
True.
so you might put in the Constitution, there is a right to compensation when someone's deprived of property. But
Hmm.
what does that compensation look like? That's a different question, and
Okay.
usually left for the courts to figure out.
Yeah, certainly the text of the legislation or a constitutional amendment would matter, as well as the development of jurisprudence to follow. Let's get into some of the examples here. So you've explained a bit the concept of takings. When expropriations occur, and let's focus on the regulatory ones in particular. So you've given some examples of how properties of value can be diminished or eliminated through things like zoning or environmental designations, boundary growth, um, without any compensation. And so, is this common in other peer jurisdictions, or do they have policies in place that provide some sort of framework?
Yeah, it turns out that it's quite common for there to be a requirement for compensation. So it's sort of the opposite situation from what we have in
Mm,
Canada, which is a lot of European countries do have these requirements that there be some form of compensation where it reaches a certain threshold. Usually, a fairly high threshold in terms of loss of value to the owner, maybe to the point in some instances where there's just no reasonable alternative use of the land anymore, something like that. But yeah, this is part of Canada being an outlier, is the idea that Canada just has no compensation at all for these circumstances, whereas everyone else is sort of battling over how much compensation, at what point should we provide compensation. It's a matter of degree versus not at all. And other academics have done sort of international studies across several, dozen jurisdictions, and it's always Canada's sort of the lone outlier, saying, well, it turns out Canada doesn't really provide compensation. It's in its own category often, and
mhm. So let's. I want to probe further on this. In to the extent you've studied the international scene, to what extent is there an issue in perhaps the threshold or the level of compensation that's stipulated as required? How does it affect things like a government's willingness to undertake major projects? I'm thinking of transit development, for example, or natural resource issues. I'm thinking especially in the First Nations context here in Canada, where a pipeline or what have you has to go through large tracts of land. Do we see regimes where they've figured out a balance that provides just compensation to property owners and does not stymie major, important economic or other government actions from taking place?
yeah, I think I think they have figured out a different balance that works. Now, that's not to say that it doesn't, provide limitations on government. Whenever, we governments have limited resources, whenever a decision costs more, uh, it will limit the sorts of things they can do. But normally, they have either a court system or tribunal system in place to deal with these claims, like we do in Canada with outright expropriation. Uh, and in the transit context too, building a transit corridor, there's going to be a lot of properties that will need to be outright expropriated and taken, and the government seems to be able to manage that through this more just process where people have the opportunity to appear at the tribunal and argue their case and argue how much fair market value is and this sort of thing. So normally, yeah, I would say that that's how we can make it work, is individualize it through having a process where the individual facts of the case can be adjudicated. Um, but yeah, I don't really know beyond saying it's been working for decades in other places. They haven't
Right.
had no sign of ever, maybe a reversal. Like that's not happening. Um,
Okay. Yeah, no, I'm sure because there's so many factors that affect a government's ability to undertake
yeah,
an initiative. Unfortunately, in Canada, it seems in in the case of transit and major projects, we seem to already have a number of challenges.
yeah, yeah,
But that does
yeah,
not to say that we don't need to deal with those unnecessary burdens that are perhaps causing that, while also strengthening our property rights. But it's certainly something to be mindful of. What sort of proposals do you envision to deal with the issue of just compensation in particular?
yeah. So in the, I guess I should say in the paper I talk about, we can sort of do a statutory route or a constitutional amendment. But either way, I think, as you said, just compensation needs to be a part of it. In the expropriation context, so the outright taking of land, that's sort of across Canada now. All the provinces have adopted the same methodology for calculating that based on fair market value. And so we could apply the same sort of logic in terms of the change in fair market value from before the regulation was in place till after the change took place. How much did the property value go down? In other countries, there's also an alternative. Some countries have this alternative, which is that you might no longer want to be holding that piece of property at all. It might be totally useless or a burden, and so actually, there's a right of sale to sell that property to the government at the price it would have been before the stricter regulation or whatever government activity took place that diminished the value of the property. So there are those sort of two alternatives: just a compensation based, or a offload the property, and the government has a mandatory purchase obligation once the property's value's been so significantly diminished. Um,
Mm,
so yeah, I think again, not getting, I guess, too deep into the debates. Calculating fair market value, even in the expropriation context, has been very controversial. How do we base fair market value? Getting back to
mhm.
like the family farm context, maybe the value to the owner is a lot more than what the market would bear. The owner would have never wanted to sell this property. How do you incorporate that into, uh, just
Yes.
compensation? Very
Mhm.
difficult, and all provinces now have sort of moved away from models where they had the flexibility to do that, and moved to
Mm,
models where it's based on fair market value, and then maybe other damages, to either other lands nearby, or also to relocate those sort of expenses.
mm. Okay, fascinating. I want to get into more of the facets of your proposals, but before we do, we've talked a lot about the rights side of the equation. But you noted in some of your earlier examples how there are also commensurate duties upon property rights holders, such as proper use of the land, don't be a nuisance to your neighbor, things like this. And you made the point that many rights certainly are not absolute. that many thinkers, the natural law thinkers in particular that you mentioned, recognize these duties of stewardship, of fairness, and compensation. Do you think like a richer moral understanding of property could make it actually easier to defend property rights publicly? Because I think a lot of people, maybe more so on the left side of the equation, have this kind of suspicion of property rights and its connection to power and interests. So in other words, by acknowledging duties and having some way of incorporating that into law or policy, it could strengthen the legitimacy of the right itself.
Yeah, I think it's possible because right now, as you mentioned, there is sort of like in so many areas an us versus them mentality, right? It's like I don't own property. This this property rights protection, it's only going to protect the wealthy. It's going to protect certain interests. I'm unaffected by that. Um, and so I think we need to do work to sort of like change that attitude. One thing I will say in addition is that I just don't think it's necessarily true that property rights only protect, the wealthy developer, right? It's just the reality is in fact actually the people that are often most, negatively affected can be the people that have the least power, the vulnerable people in society who are kind of forgotten about. And when you look at a lot of these cases, the examples given in the paper, it's not uh, I don't know, billionaire developers or companies that are being affected. It's, family farms or individuals who there's, for whatever reason, they've had the unfortunate uh, situation where they're uncompensated and yet their property is being used for the public benefit. They sort of lose everything. And getting back to the example I gave earlier with the police knocking on the wrong door, right? The one
Mm-hmm.
person now is negatively affected, and so yeah, I think uh, uh, there is a lot of resistance to property rights. I think it is based on this idea that they only protect certain people that are a class of people that maybe I'm not a part of. Um, and whatever we can do to sort of change that framing would develop broader support, whether it be through what I just talked about in terms of recognize, explaining the situations where property rights would protect everyone, not just the wealthy folks, but also dealing with what you were mentioning, which is, property rights aren't absolute. There are these sort of other obligations that go alongside it, and um, yeah, so working to kind of temper this extreme attitude on real,
Mm-hmm.
like many issues on both sides, you have people on the other extreme who do believe property should be pretty much absolute and no one should be able to do anything with my land other than me.
Mm-hmm.
So yeah, it goes both ways, but I think especially in today's environment, we need to find ways to work against that sort of tribalist mentality of I'm either
Yes.
in this group protected by the right or I'm not, and if I'm not, I don't want that right to exist at all.
Wise words. So let's get into the proposals, Paul. You noted you've proposed two main paths forward. So one is a constitutional amendment, perhaps a little more difficult, although maybe not Section 43, which yes, Dwight Newman has just proposed as a way to perhaps strengthen property protections, and then the statutory amendment, so federally and provincially. Why do you see I think in the paper you know legislation, the statutory route is the most realistic and effective first step? Why do you think so?
Well, I think mostly from a practical perspective, right? Just to remind everyone about the process for amending the Constitution to add a new right that would apply to both provinces and the federal government would require the agreement of the Senate and House of Commons and 7 provinces with 50% or more than 50% of the population. So uh, you're dealing with a situation that's very hard to achieve. It would require a substantial amount of work and a substantial amount of agreement. I would think there'd need to be almost some sort of galvanizing event that really calls to action people across the country that they want this change to take place. Because the other sort of thing that always comes up when people talk about constitutional amendment is, well, there's a whole host of issues that people want to amend. And if you're opening the Constitution, let's bring in these other issues too. Let's bring in my issue. I'm not going to agree to your amendment unless you bring in mine. And that's why we haven't seen any successful attempts. We know Meech Lake and Charlottetown failed. It's very difficult. And so, yeah, I think just practically speaking, the statutory regime would go a long way in rectifying the checkerboard situation. It would have consistent protections across all different classes of property and all sorts of different ways property can be essentially taken. Um, but it's much more achievable, and it also has other benefits in that we can spend time really defining things like just compensation, right? We can spell them out in detail in a statute versus in a constitution. All the provisions are quite general. They're meant to be expounded over time and by the judiciary and, well, depending on your theory of the Constitution, by other state actors might have a legitimate role in that too. But yeah, so there's a lot of unknowns with the constitutional
Mm-hmm.
process. We saw with Section 7, the courts decided to go down a totally different route than the people who wrote the provision thought it would go down. So that's the section of the charter that protects life, liberty, and security of the person, and not to be deprived thereof, except in accordance with principles of fundamental justice. And at the time, the framers of that provision thought that meant you could be deprived if due process, fair procedure was followed. The Supreme Court, in their first decision, they decided to interpret it to no, this includes substantive rights as well, like um, overbreadth, disproportionality, and vagueness, arbitrariness, these sort of a whole host of other reasons why legislation could be struck down. And
Mm-hmm.
so the same thing could occur in property rights. It could go one direction or the other. The courts could interpret it very narrowly, which is concerning to some people, or they could interpret it very broadly, which is concerning to other people. And
Mm-hmm.
so with a statute, there's a little bit more control over that and
Mm-hmm.
a little bit more um, detail that can sort of spell out how exactly the statute is meant to function.
Mm-hmm. So why don't you just briefly then, Paul, give us the highlights of what you propose at the statutory level, and then people have to go read the paper to get the full.
Yeah, so I think sort of I have four, I guess, pillars or things that I think should be in a statute. The first is the just compensation, which we talked about, and not only just compensation where property is totally taken or destroyed, but we're dealing also, or I propose at least, we should deal also with the situations where the property is effectively destroyed, or almost the majority or almost all of the value in the property has been taken away by regulation. Another facet is sort of the due process element, which is, people should have the opportunity to be heard by a fair and impartial decision maker to sort of determine whether this taking is legitimate, whether the compensation being offered is fair, those sorts of things. Another element, which we haven't talked too much about, but is sort of a just cause. I think there should be a requirement that if the government says they're destroying your property in the interests of the public, there needs to be some justification for what they're doing, and it needs to be a legitimate purpose. We don't want the government to be able to take property to give to their buddies, and let them do that. And we have seen that in some instances where. In the United States, government wants to develop a certain area, they expropriate the land and then give it to developers or sell it to developers. And so, I think there has to be some requirement for a public use or something along those lines, some kind of justification. And then finally, alongside that, sort of relatedly, there needs to be some degree of proportionality. I don't think government should be able to, take someone's property or fully destroy someone's property to achieve a very minor objective that's kind of
Mm-hmm.
disproportionate with what the damage to the person actually is.
Mm-hmm.
Um, so so yeah, those are the sort of four pillars that I think should be part of any statutory or constitutional amendment to further protect property
Hmm.
rights in Canada.
Now, does that mean federal provincial coordination or the federal government lead? Would you recommend?
Yeah, that's difficult because so it turns out, in the Constitution Act 1867, that regulation of property is really a provincial matter. Property and civil rights fall under the provincial powers. So most of the time, it's a provincial issue. That's not to say the federal government can't interfere with property. They often do too, and the federal government has their own expropriation regime already. So uh, unfortunately, I would say that means that it's sort of the provincial level, in my view, is more critical.
Yeah.
I say unfortunate because that means all the provinces would need to separately kind of enact this type of legislation. Whether the federal government doing it first would inspire, other provinces or not, I don't know. More of
Yeah.
a
No, it's important to hew to these appropriate jurisdictional lanes, and as you note, property is the primary jurisdiction of the provinces. That should be respected, but the federal government certainly has oversight over, through their legislation, various agencies and in areas of law. So leadership, and then following by example is certainly a route, and there are many fora for federal provincial collaboration, maybe less collaboration than than the name implies, but these are interesting times. And before we close, we might as well just talk about that galvanizing circumstance that certainly don't want to be alarmist at all, because this Cowichan decision was just at a trial lower court level, but there are many other cases like it, as I understand from my colleague Karen Restool, who leads our Indigenous program, making their way through the courts, where property rights could be subject to some sort of override by Indigenous rights. And we'll have to see how that case unfolds. But a well-respected scholar who well, I do as well, Dwight Newman has kind of mentioned that section 43 of the Constitution could in fact provide means of addressing, strengthening property rights in a more substantive way. Especially if the courts overturn basically make it law that Indigenous title is superior to fee simple in certain contexts. It would be hard to legislate over that, right, without a constitutional
yeah,
protection. So I just want to get your
exactly.
thoughts on that. If there, what do you think about this Section 43 idea? If there is, like the Emergencies Act overuse or threats to private property as a kind of remedy.
Yeah, I think so. In the Aboriginal title context, that is sort of the only option because Aboriginal title has the constitutional protection. And so in order, I mean, at least I should say, I haven't considered this deeply, but it would seem like um, the only way to change the court's decision in that regard would be to have a constitutional amendment, something of equal status to what the court says Aboriginal title requires, which is, from my understanding, is sort of it's a superior right to the crown interest and any interest derived from the crown, which includes, the fee simple that you were talking about. So in that context, I think constitutional amendment is critical and necessary. In our context, it it's less necessary. It's more what could a constitutional amendment achieve? Well, it could create a little bit of a change in culture, change in how the courts view property in some instances. Um, one of the questions that I had when sort of preparing this paper is a lot of the countries that we look at as examples of places that have much stronger property rights protections are countries that we think of as more collectivist than Canada. A lot of the Scandinavian countries and
Hmm.
places in Europe. And sort of the question is, well, the question I had was why are these countries protecting property rights when Canada is not? And part of it might be just once you entrench these in your constitution, it becomes part of the culture and part of your beliefs on how government should act and the sort of limits and scope of government's ability to interfere with property. And so
Mhm.
I think that it could create a broader sort of legal cultural shift to have it entrenched in the Constitution.
Mm-hmm.
Obviously, the other sort of difficulty with Section 43 is, again, we'd have to be going either province by province or a small group of provinces at a time. And so then we end up with a patchwork with different provinces with different protections. I mean, that could inspire the other provinces to also come on board when they see maybe there are benefits, economic benefits to the provinces that have enacted the constitutional protections. But yeah, so there are still challenges. It's not as hard because we don't need everyone or a majority of provinces to agree at one time to this constitutional amendment. Um, but still difficulties, just like any constitutional change.
Mm-hmm. Well, fascinating stuff and times that we're in with respect to these issues, and a very timely paper on your part, Paul. It seems as though there are many examples worldwide of this balance of property rights protections and common good, government and other interests that we ought to further study, legislatures and policymakers across the country. And so I encourage people to check out Paul's paper when it's released. And Paul, I just want to thank you for joining us and for helping us think more deeply about one of these foundations of freedom, fairness, and the rule of law. And if you enjoyed this episode, please like, subscribe, and share it with someone who cares about Canada's future. For the Macdonald-Laurier Institute, I'm Peter Copeland. Thanks for joining us.